Let's call this work session to order. This work session deals with 2018-5 and the S version. Let's go around the table and identify ourselves for the record. Big training with the assembly.
Forrest Dunbar.
Christopher Constant. John Weddleton.
Steve Peterson.
Okay. We have two from the Department of Law.
Todd Sherwood, Assistant Municipal Attorney.
Okay.
All right, Forrest? Sure. So we'll start with my version, and then I think we'll discuss John's S version. And, you know, this ordinance is up for public hearing at our next meeting, but the 13th, I believe. But I am comfortable if we can't reach some kind of consensus, or if we want to continue working on it, I'm comfortable pushing it for another couple of weeks. But, you know, just as an introduction, and I think everybody knows, the APD presented to us a policy that would regulate their use of unmanned aerial systems, or drones, which I'll call drones from now on. And, you know, myself and a couple other members expressed that we'd like to have something similar to that policy actually in ordinance, actually in code, rather. And so that led for me to work with Todd to help draft this. And it wasn't, it was just because at the time Dean was working really hard on basically a lot of stuff Dick was having to do. And so Dean didn't have the bandwidth, and so Todd graciously agreed to help draft the version you see here, 2018-5. Yeah, so Todd, would you mind just discussing a little bit? We'll start at 3.102A, just discussing a little bit sort of how this works and how you came to these conclusions.
So one thing I should say at the outset, just so there isn't any confusion, and Forrest referred to this, under the code, we can be called upon to help the assembly or the administration. So in this case, if I say something, I don't think I'm going to say anything controversial, but it isn't necessarily reflective of the administration position to the degree there is one. One thing I would mention, Lieutenant Vandegrift and I and Forrest, the three of us all met and kind of went over this, which is, again, not the police can speak for themselves, but, and also working with Lieutenant Vandegrift separately, I had reviewed the policy. He mentioned it was in draft form and suggested some changes. Again, just a little bit of background. Within our big legal research database, I was pleased to find we have a treatise on aviation law, and in there is a section on municipal drone ordinances, which cover the gamut, and they're fairly new across the board, I would say. So I looked at some of that, and a lot of it was discussion between Forrest and I as far as what goes in here. And what he was after was, these are things that would be restrictions on use, and the focus was on privacy, as it starts out in 3.102. So the focus is, we want to stay within the Alaska and U.S. Constitution. We want to ensure people's privacy. A1 refers to the state law, which, by the way, is the only law currently in the state code on the use of drones, or UAS. And it basically lays out the parameters. It says there's certain things at a minimum that a police department must have. One of those things they must have is the policy, which you've heard discussion of separately. So this first one just rides on top of that. The second one, that it shall not be used for routine patrol activities, and the police department can tell us a little more about what routine patrol activities might be. But in other words, it's not going to be like, I think typically if you have a dash cam, it's on under certain circumstances that might be described as routine. This wouldn't be used in that way. Number 3, that it can't be used for warrantless searches that are specifically seeking evidence as part of a criminal investigation. So that is not to say that it can't be used for tactical reasons in a SWAT team type of scenario. keeping in mind that typically, and again, the police may want to address this, but typically, if they were to use this, it's not being used as evidence gathering tool. It's being used for officer safety. It's being used to try and take care of the situation with, in as peaceful a manner as possible. It protects life. Now, incidental to that, there may be things that are later used as evidence, but that's not the goal. Then number 4, that it won't be used in a manner that violates a person's reasonable expectation of privacy unless supported by a warrant or in accordance with a judicially recognized exception to the warrant requirement. So the first part of that is really what you see in any type of case law that talks about when a warrant is needed. And I used to be a prosecutor for the state and for the Air Force. So this kind of thing comes up all the time, and often the balance is always looked at. Does a person have a reasonable expectation of privacy? Just as an example, there went through a period of time when the question was, does an employee have reasonable expectation of privacy in their desk or in a locker, that kind of thing. So this is just saying that if there is that judicially recognized expectation of privacy, you're going to need a warrant. And then the second part is pulled right out of state law, which basically says, in the state law we refer to in number 1, that you have to have a warrant or a judicially recognized exception to the warrant requirement, because the drone is going to be typically capturing images. And 2 of the most common of those judicially recognized, in other words, by case law that's gone to, say, the Alaska Supreme Court, are what's called plain view. So if the drone is up and looking in a backyard and they see an AR-15 rifle laid out there in the grass, at that point,
Eric, one over here.
it's in plain view. Or the other one is exigent circumstances, where things are moving so fast that you have safety concerns and there isn't time to go out and get a warrant, but in the meantime, you've seen this evidence of crime and it's been captured, say, by the drone camera. Number 5, we know the military can and has for years weaponized drones. That's their business. The second part is that it can't in and of itself be used as a weapon. So you can't fly it into somebody or something. Number 6, not to be used for surveillance of persons or groups involved in constitutionally protected activities. So simply because someone is having a large protest march or a rally in a park, can't float over there just to kind of check things out. Now, on the other hand, if the police say, no, there's 2 specific individuals and they may well have a warrant, they have probable cause to believe that there's some type of crime ongoing or about to happen, and they come up to, say, a gathering, or they want to use the gathering to hide their crime, certainly they could use the drone then and it's capturing the gathering, but the focus is on the individuals that may be about to commit a crime or committing a crime. Number 7, that it wouldn't be used for traffic enforcement activities. You used to see a lot of signs that said radar patrolled by aircraft, that kind of thing. So they can't use the drone that way. But for accident investigation, and that was one of the discussions, it can be very, very useful to get an aerial view of the accident and do accident reconstruction, so it allows for that exception. Number 8, because as you know, the Anchorage Police Department is the largest police force in the state, and they are sometimes a resource for other agencies, I assume sometimes federal, other local agencies. They have, I think, agreements with other agencies. But in any event, any drone owned by a municipality cannot be used by any non-municipal agency. And that would be whether it's federal or state. One thing I should say too, although the context of this and all the whereas clauses revolve around the Anchorage Police Department, one of the discussion items we had, and something I had suggested, was that this applies not only to the police department, but to any municipal agency, because as you can imagine, this is a very useful tool for, say, the Parks Department,
the fire
planning and zoning, for a utility. And this way, we're kind of anticipating the future, because they all possibly could be used in a way to violate privacy too, so this way, they're all covered. B, anytime the Anchorage Police Department or other municipality of Anchorage agency considers a change to its operational policy for UAS, that change is to be brought before the assembly for review. Another discussion point we had internally was, do we say review or do we say review and consideration? And my advice was, you want to keep in mind the separation of powers. So the word consideration was dropped so that it should be clear from this that the idea is the assembly, as always, can review anything, but it doesn't mean they get to vote on whether they like this internal use policy that the Anchorage Police Department or the Parks Department has come up with. But, I mean, if it really, really didn't like something, then you could draft an ordinance and say this is going to change. But that way it allows the executive its prerogative and allows the assembly its prerogative. So, I would expect if there's any change, it would come in the form of informational memorandum to the assembly, and then if they want to do something more at a hearing, make a change in an ordinance, they could. The definition section speaks for itself. Those definitions came from the policy the police department had, and that's it.
I want the record to reflect that Eric Croft joined us and Dean Gage joined us probably about 20 minutes ago, so thanks for being here. Do you want to do the S version? Who's the sponsor of the S version? Who drafted it for you? Was it Todd or who did it?
Combination, folks at ACLU, I gave it to Dean, and he.
Are you comfortable going through it now, the S version, or?
I think I can, yeah.
Okay.
You
Go
can
ahead.
use that.
Yeah, it's fine, unless, Chris, you had something specific on my version first.
Oh, well, it's in both, so it doesn't matter, wait, yeah, it's good. We let Dean
Good.
speak on it.
Just for clarification, all I did was take Mr. Weddleton's draft from the ACLU and put it into the legislative drafting format so you can see what's being changed. I didn't look at any substantive language or recommend or endorse any substantive language here from my legal expertise. Let's do by legislative drafting. Skip was in the platinum, that's all. So I don't have a recommendation.
Wisely, pushing off any blame, so I think that's correct. So I'd like to make a few comments and then invite Tara Rich from ACLU to make some comments on it. So, and first off, when we first looked at this and heard there were drones, my thought was good, let's go get some bad guys with them. And then seeing the policies, starting to understand there's some issues and people are worried about safety and privacy and so on. I got a call from ACLU that had some thoughts on it, some amendments, and kind of offer that up. And in general, what I think is the one that Forrest is putting forward says you can't use drones except in these cases. And the ACLU version roughly says, well, you can't use drones except in these cases. And to a large extent, you land in the same place. There aren't, it's not a huge difference. And I'll let Tara speak on that a bit. There are two things that would highlight. One is that it was my work, not from them. That was the requirement of policy changes to come to the Assembly for review. I recommended pulling that out and just putting it in an annual report that's in the ACLU version. And just thinking that the policy is probably things like who's going to call who to get the key to unlock the drone and things. And that's not something that I would expect we would want to look at off of it. I think someone would need to maybe at some point balance what would the policies look like. Who we need to see. So maybe Tara could come up in a few minutes to describe the highlights.
Sure. What would you like?
Well, we need to record it on the, we need to be able to get on this system here so they can hear you. We need to get your full name, who you represent, so when later when they're transcribing, they get it all down.
Great. Should we just have a seat here?
Fine.
As John mentioned, my name is Tara Rich. I'm the Legal and Policy Director of the ACLU of Alaska and the source of many of the changes in the S version. So just to walk through briefly, before we dive into the actual substantive changes, there's one particular concept that's pretty important to understand when you're comparing the original version and actually the state law that applies to drones. This is the bill that was passed, I think, last year at the state level that requires drone usage along with the original version to comply with either a warrant requirement or judicially recognized exceptions to the warrant requirement. And so I think primarily what the ACLU version is trying to do is actually cabin that a little bit further. So here's what we've found. There is a number of cases on essentially what is the reasonable expectation of privacy that an individual enjoys. And there's one particular case that's quite on point. It was a U.S. Supreme Court case coming out of the 1980s. The case is called Serrallo versus the United States. In that case, the Supreme Court dealt with a situation in which police had actually borrowed an airplane and had flown it over a very low altitude over an individual's property. They did not have a warrant, but they were able to look outside of the plane and see down in the backyard of this individual's house, which was completely fenced around, marijuana plants growing in the backyard. And so that gave them enough probable cause to arrest. And this issue about whether that person had a reasonable expectation of privacy to the contents of his backyard made it all the way up to the Supreme Court. And the Supreme Court said no, that because anyone in that airspace would have had the ability to view what was growing in the backyard, he did not have an expectation of privacy. So the way that the law is designed, and these judicially, when we talk about recognized exceptions to the warrant requirement, it is supposed to keep pace with where society is. And the problem with that, as we've recognized, is that technology has far outpaced where we are in terms of actual privacy rights. Drones are very popular. People can buy them at any, Costco or wherever they want to purchase. Exactly.
Who's going?
But that is eroding our privacy rights. So it's particularly necessary when you care, when you believe that it is worth protecting the privacy interest in that actually I don't necessarily want people to view the contents of my fenced-in backyard, to protect them in policy and through ordinance or police department policy, because the courts are not going to necessarily step up and do that for you. So as Assemblymember Weddleton said, diving into the changes, the primary difference between the original version and the one that we recommended was to make sure that we got out of the you are able to use drones as long as you don't do the following, because that keeps us within the judicially recognized exceptions requirement. And it's a blanket prohibition on the use of drones unless you meet certain requirements. And so if you look at subsection A, that is the blanket prohibition, and then subsection B goes through the exceptions. So I'll just walk through those briefly. There's an exception for consent. This is broadly recognized. There's a large body of case law around what is consent, who can give consent for whom, but it's designed to encompass that process by which police can get consent. There's an exception for emergency situations, particularly in Alaska. I think this is really important. We've seen this used for search and rescue operations. We had conversations with APD where they explained, we might have a situation in which someone is missing from a nursing home, and you can just do a lot more with a drone in terms of covering area and finding people in a much more faster and safer way. We don't want to inhibit that. So there's an exception for any instance in which there's an imminent threat to life or safety of a person. That's in the emergency situations. But it does require both that be documented that the factual basis for the emergency be documented, and that evidence that's gathered be limited. And so the third exception would be either a warrant requirement or a court order. In either of those cases, it's perfectly permissible to use the drone in a criminal investigation as outlined in the warrant or in the court order. And then I believe this was maybe Assemblymember Weddleton wants to speak to the traffic accident investigation. We didn't have any particular concerns with being able to use these to investigate traffic accidents. I understand that I think that the purpose is to clear the roadways much faster if you're able to use that to document what happened. And then any non-law enforcement operations, there's a generalized exception primarily for training purposes. Maybe it's practice flights, showing people how to operate it. But again, that cabins the ability for them to use any evidence that's gathered or any images that are gathered from the non-law enforcement operation, being limited from using that in court. Subsection C provides that we wanted to make sure that if the drones are not used in compliance with the chapter, with the ordinance, that there's not. That this must be another addition with facial recognition or biometric recognition being used as part of the drone. We also wanted to include that APD both not loan out the drone for use by another agency for which the Assembly does not necessarily have the ability to cabin the policies, but also the flip side of that. So this came out of conversations that we had I think, with the police department about using technology of another agency, and so making sure that it just follows the policy, regardless of whether it's APD equipment or belonging to someone else. And we wanted to make sure that in subsection F that there's a data retention requirement, which means that data that isn't relevant for a criminal investigation does get wiped. That there's a process for wiping that so that people's privacy can be protected and it's not sort of amassing a large amount of data. And finally, that in order to be able to use evidence in a court hearing, that it must be gathered in compliance with this ordinance, and to make sure that the public is aware of how these drones are being used. And so this is in subsection H, doing some sort of report annually that describes how the drones are being used, how they're being, whether they're being effective. So one of the features of the report would be the number of arrests and potentially the number of convictions, if that's trackable, so that we can see that this is actually effective technology and it's assisting the police department. And it also, I think, engenders a good relationship with the public so that they know, this is where the drones are being used. And I'm happy to answer any questions.
Thank you. John?
I guess, Todd, did you get a chance to read it? Any comments?
Yes, I did. And I do have some comments. Do you want them this time? And I should say, as I said, Leanne was here to talk about the one that I worked on with Assemblymember Dunbar. So this is just me talking. We haven't talked. And some of this is minor stuff that would be taken care of in cleanup. It uses the term political subdivision several times, which the MOA doesn't have any political subdivisions. We are a political subdivision of the state. In B2, one of the things I noticed there that talks about, for emergency situations, about life or safety of a person, I'm imagining circumstances where you might have property in danger, but no person in danger, but it still might be an emergency, like the mudslide on the highway or the forest fire. People are out of the way. So, if this were going to be adopted, you might want to consider adding something about property there, or maybe just a building, no one's in there, but you see smoke coming from the roof, and the fire department wants to it'll look. And then within that, so the B2B, B in parents, talking about filing a sworn statement. I guess I would wonder how that would work, because if there's no existing case, especially as I read this wasn't a criminal matter, it's an emergency, it's like a search and rescue type of thing. There's no case of any kind, there's no criminal matter. I think if the court got a statement, they'd say, what are we supposed to do with this? They don't have a place to file it. So I don't know that that's practical. Maybe something like a statement to the police chief saying, here's why we use this all of a sudden. And some of that sort of thing, I believe, is already in the policy. Then number 4, and this is something that really the latter half of that talks about, if you're getting this court order, you have to say no alternative methods, data collection, it's cost prohibitive, it's good for 48 hours, but no longer than 30 days, no matter what. And the police might want to speak to that aspect of it, but it strikes me that that may be going too far in tying their hands in terms of everything they have to meet. I'm also not sure, it's not clear to me when this would get used versus having a warrant. In 4, the latter half of paragraph 4.
You know what, I wonder if that got renumbered, because that's
Oh.
a 3B on it.
Okay, so it's 3B. Yeah, I've got the one that was originally given to me. So it'd be 3B in this. And this is also small, more wording thing. The idea, as I understood this, was this is a list of what you can't do. So a lot of these say it shall not be unlawful, but then like with 5, it talked in, well, I guess it's 3 and 4 now, but it starts out with it may be used in this way, it may be used in this way. It's just a question if there's a rewrite, maybe some might want to be more consistent there. Then under, is it 6.5 now? Exception for non-law enforcement operations. It talks about it's not unlawful to be used if it's in compliance with Alaska statutes, and if no part of the information and no evidence derived from such operation may be received in evidence at any trial. The absolute blanket bar on using anything gathered in a criminal trial. And that may go too far. I mean, you can imagine any number of circumstances. Maybe as they're putting it up, they happen to catch a crime going on over here that isn't even the thing they're looking at. This would seem to say you can't use that, and maybe it's the only evidence of that. So again, that might need to be looked at and considered rewriting. What was F, and now maybe is, no, I guess it is F on the other one. And again, police might want to speak to this, but it talked about deleting no later than 24 hours after collection, which that may be a quicker time frame than, I just don't know what would go into that, but whether that is just too soon for them to be able to take care of everything that they need to. The other thing that I think would require more thought is how that interacts with our public records ordinance and records management and things like that, because it may be that there are things that they're a record that we have to keep. Doesn't mean it's a public record, because the whole public records law balances right to privacy with public's right to know also. But it just may be that making that quick judgment call to delete is too quick, too hasty, the way this is written. And H, the police may want to speak to that too, whether they can effectively do that. And my guess is that things like the number of convictions resulting from information gathered with a UAS, pretty hard to say, because it's going to be a tool, one of probably many tools that was used in making a given arrest. So, but again, that would be for the police. So that's kind of the off the top of my head comments.
I'm going to go to some members on questions. Eric, you're first.
First of all, really fascinating distinction between these two, sort of theoretical, legal distinction. It's always been harder to define all the things you can do than just say the prohibitions. It's the reason 10 Commandments says thou shalt not. Everything else you can do, but here's the things you cannot do. And to say you can't. Here's the 10 things you can do, but everything else is prohibited. Is both a different theoretical setup and really hard to it's sometimes easier to define what you can't do than what you can. So this distinction is really fascinating. That was in carrying on in the questions that Todd asked. So it's Miss Rich?
Yes,
yeah.
that's right.
Really good presentation. So on exceptions B2, it says the request shall document the factual basis. I mean, I take it that language is from the normal situation in other contexts where we ask a judge for permission, but what request, if it's an emergency situation and we fly a drone, what request are we referring to?
And this may be something that the police can speak better to in terms of actual internal procedures, because I probably would agree with the city attorney's characterization about an affidavit arriving at court divorced from any context of a case is probably something that's going to be looked at with suspicion by the judge. But I think in terms of a request, that could be something that's internal. I think the important part in terms of privacy is that this is designed to stay within the emergency situations exception and not to say, okay, we have probable cause to believe, or we have, even without the probable cause, we have a suspect that we believe has committed several murders, and so we're going to fly a drone around to follow this individual and track his movements and anybody who may be surrounding this individual. And so I think it's less important maybe the format of the request. It could be an internal document. It does not necessarily need to be an affidavit that's filed with the court, but it does. The intent of that provision would be to keep the sort of intent of emergency situations, the missing person, as opposed to a criminal investigation.
Well, yeah, can I keep going a little bit? Yeah, you're ahead of me on. I didn't see how a court would. I think you're right. I'm not sure how a court would receive a document. But even before that, I'm not sure where the request was. Mm-hmm. That is, yeah. So I guess you're right. That would depend on how procedures, how they use that. Possibly at some point, an officer says, I would like to use a drone for this, and so it should document the factual situation. And then on the second point, on the F on page 4 of the 5, so it isn't just a prohibition on using in court, which I guess I'm possibly okay with. This says you can't use at all, it has to be deleted. So if out of the police context, some of the ways we want to use drones are running down our pipelines to see if they're leaking, running down our electrical lines to see if they're still up and running or something's down, sort of routine utility or other flying around the port looking at pilings. If doing that, they get information of criminal activity, a crime going on, an assault going on, marijuana being grown here. Am I right that this, not only can't that be used in evidence, that can't even be used as the basis for a search warrant or anything else?
It depends on what it is, because as I understand the exception for emergency situations, if it's a threat to life or safety of an individual, then it could be, then it would fall within that exception. So it's not generally to be used for, I think kind of backing up again, we're back at this paradigm of if we were to not have a policy and we were just to try to use what's enforced by the Constitution, the constitutional right to privacy plus the Fourth Amendment sort of working together, then the police are not certainly not required to sort of blind themselves to criminal behavior that's going on right in front of them.
But
They could
this
use
requires
this,
them
but this
to.
would go further,
Correct.
correct? Yes, so this would be more stringent, and this would allow them to use that information just with a drone if it's a threat to life or safety.
I'm not talking about the section on police use. So this is municipal light and power sees something that is not on their utility line, but is a home or other area than the target, and this says may not, well, it said no at the beginning, but may not be used, copied, or disclosed for any purpose. So we're always free. I mean, the Constitution is the limit, right? But this confines us even more.
Right, that's correct.
Okay.
So I think that's a policy decision for you folks. If there are drones used outside of the sort of criminal investigation police context that you want to use for administrative purposes, to run along a pipeline, I think that would require a separate sort of spelling out of what those uses are going to be. I would, caution against maybe sort of making a too broad of an exception for things that might be able to sort of, if, you have somebody who really wants to, there's certainly good reasons why you might want to capture an individual who's a threat to public safety, but isn't using these administrative exceptions necessarily to invade the privacy of a broad number of people who may not be suspected for criminal activity. So I think it's just a policy decision how you want to create those exceptions.
Okay, thank you.
That's fine.
Yeah, no, that's fine.
Chris?
Yeah, I have a few things.
So which one you working off, the original or the expert?
Both, but the first one, we'll start with the original. So I noticed what seems to me to be a slight conflict on part A, number 3, and part A, number 7. Shall not be used for warrantless searches that are specifically seeking evidence as part of a criminal investigation, and using them for accident investigation. In fact, they may be one and the same. Like you may have criminal activities that resulted in a car crash and you need to document that situation. And so I think we need to work out the conflict between those two items there in a way that allows the police to document the scenario, whether it's criminal or civil, if it's traffic. And so that's one thing that I see as a potential pitfall. I would predicate my statement now on I have full faith in the police chief and our mayor, but I don't have full faith in the future, and the times change and new leadership comes, and so I do have some liberties concerns on these issues, and so that's what I'm speaking from, not about today, who sits in this room, but who may come in the future. Now, I was the one who, or at least one of the ones who proposed to add a higher standard rather than just review of the policies for adoption or somehow having an opportunity to ensure that the policy changes that come in the future would be in line with what we set out as policy. In this version, I would think that what I heard today is that review is the standard that's generally acceptable, but I would like to know then if it's allowable to have that review 45 days in advance of implementation so that we can have 2 meetings if there is something that's in violation of what we would call generally accepted practice, what we would like to see in the code. Because review could be a year from now, review could be 6 months from now, review could be very flexible. But if we put in a bar that says, we allow you to change these policies, we just want to see them in advance with enough time that we can respond if we need to, would give me great comfort in working forward on a policy that works like this. Because I actually am in support of a policy that is more flexible than more restrictive. But I also want to have protection in there, and the protection comes from the representatives of the people, I think. And then flipping to the next version. Under the consent issue, I think that in Alaska there's this idea of one-party recording, one-party notification. And so I do have a little bit of concern that if someone gives consent on their property that the drone could be used, if it's right next door to a property that the police want to look at, that then in fact might be a way right through all of these protections. So that's one concern that I have. I believe that the request for the document, the policies that are established, that the chief has to authorize the use. And so I think, at least what I've read, the chief or designee. And so that probably is referring to the chief. And other than that, I think I'll
Other questions for Sunday members?
Do you want him to
Before I
repeat
go
the
to
question?
chief. What, Eric?
I said, do you want him to repeat the question? But,
there was no question, but there's one other thing. I did ask her to be paying attention to chickens and
Oh, God.
Talking bear food?
FYI, because this issue is.
It's all about chickens with you.
Chickens are just bear food, waiting to
It's actually
happen.
covered, I found it, it's in there. You know,
Mr.
I
Chairman?
Yep.
Pete?
Thank you, Mr. Chair. I was looking at the noted F on page 4 of the S version. And they're saying we must, delete it within 24 hours. I think we need to have an exception in there for police action or something, so that, ML&P or the fire department or whatever could review some of their footage afterwards to see what went wrong or what they didn't do right, or how we might change procedures in the future. We did some firefighting like on McHugh Creek. They use drones down there to try to figure out, well, where is this fire spreading? Are we going to get to that fire? And then after they got done, they could use that to review some things that they did, so they might make some improvements the next time they got in that situation. Just throwing that out there.
Chief, do you want to give us a comment on both versions of this?
Sure. Thank you, sir. I will start then with the original, before we started. And just point out that Mr. Sherwood's correct. The original is based on a collaborative process between Mr. Dunbar, Mr. Sherwood from Legal, and the police department, specifically Captain Vander, who's been sort of our project leader on this. And it was based on a draft policy that we put together, which was also done in collaboration with the ACLU. We talked to them, we looked at their recommended policies, and tried to comply with what they thought ideal operating structure was as much as we could, but still also maintain our operational needs. And so that was kind of where we started too. Generally speaking, because we worked on the development of this particular draft, we like it. We agree with most provisions. I will tell you that in paragraph B, the requirement for policy review, I have some concerns about that. I'm not sure if the Assembly really wants to get in the business of developing and reviewing police department policies. That's a pretty massive realm. But what I will say is that first and foremost, our department is very transparent with the policies we do have. In fact, most of them are posted online and they can be viewed at any time. We would gladly do that with this ordinance or this policy as well. And all of our policies are developed and take into account existing law. So we would never put a policy in place that conflicted with law, because that's just asking for trouble on the basis, of all of the people who are working in the police department, the things they're doing every day. So I think it's unlikely that if the Assembly set forth things that we were prohibited from doing, that we would affect a policy that was contrary to that. And then I just a quick comment on kind of the two paradigms, the two different versions. I actually tend to agree with Ms. Rich in that the court system and legislative bodies do have a hard time keeping up with technology and things that develop on the ground. So I think that the model of the original one and sort of identifying the things that make us uncomfortable, we don't think we would like, and prohibiting those makes sense, and trying to specifically identify the things that are okay, it is sort of doomed to failure, because you're never going to be able to keep up with things as they're developing in the real world. So I tend to feel like that's a more realistic approach for success for everybody involved. So that's just kind of my general overview of the original version. Okay, and like I said, Captain Vandegrift has been our project leader, so if you see him elbow me in the ribs really hard, it's because I somehow got off track. So with regards to the S version, some of these things have already been touched on, and I think I have an older one, so if I get off on the numbering, that's probably why. But under exceptions for emergency situation, I had the same concern with reference to sentence A and B in that paragraph about, who the request is going to, and I think the already identified issue of us, the police department trying to go to the court and filing a statement of some kind without regards to any case, civil or criminal. I think probably get thrown out of whatever courtroom that was for attempting to do something like that. The paragraph about court orders and the requirement for the order to not be greater than 48 hours and no longer than 30 days. Search warrants typically are granted for 10 days, and then an investigator can ask for longer depending on the circumstances. And I'm not an attorney, so I generally don't know if the assembly can restrict a judge's discretion on something like that. So anyway, that's a point of interest. The exception for non-law enforcement operations and the sort of discussion about in no way, shape, or form can any of that stuff be used. And I guess my question there would just be, we use evidence all the time that was gathered in circumstances that were not designed to be for law enforcement. However, typically that's done with a search warrant. And so I'm just wondering if we could prohibit the use of a search warrant for any of those things. I can imagine like MLNP or frankly anybody else, even some civilian outfit that's operating drones, we become aware that maybe there was something that was criminal nature, and we go through the normal investigative process, apply for a search warrant. If it's a judicial officer that we have probable cause to seize that evidence, that would then be sort of, that's a normal court process that would be in conflict with this. The paragraph, I think it's still paragraph E, MOA owned and operate U.S. shall not be permitted for other agencies and so forth. And we do have a lot of interagency memorandums of agreement and understanding where we operate with other agencies. And so this could potentially create some conflict with some of those. Typically, we don't just hand over any equipment to the police department to other agencies. If we have equipment that another agency wants to use, it comes with officers to operate it for a variety of reasons, but that's also to make sure that it's operated in accordance with our own internal policies and procedures. We don't just hand stuff over and let people use it however they want. So that would just be an operational concern for us because it's kind of goes contrary to the way we typically interact with other law enforcement agencies. So section F, it says no data collected on individual home area other than the target justified deployment may be used, copied, or disclosed for any purpose. And I guess that, my question there is, what about lawful purposes? If we have some lawful purpose that's already established, this seems to be preventing that, and that seems a little bit contradictory. Destroying it within 24 hours, I think Mr. Sherwood pointed out some issues with that. We would have some, there could potentially be some issues with that as well. We want to prevent any sort of situation where we're directing police employees to destroy something that then becomes evidence, and they're destroying evidence, which is actually a crime and could be problematic. So we just want to be careful about that. And I think all of our records and retention stuff is already covered by law. Anyway, I think just generally speaking, again, I sort of tend to agree with Ms. Rich's statement that this S version is frankly far more restrictive than established law based on the Constitution and all of the operating parameters that we normally function under. I guess I would point out that if this were enacted in its current form and it basically created this much more restrictive environment for the use of UAS, there would be nothing preventing us from going and doing all of those things from a helicopter, which we can do basically any time of the day or night now just by calling the troopers and asking for it. So I'm a little concerned that we're trying to establish new restrictions on police operations in this way that are sort of contrary to the existing legal structure that we function under every day that protects people's rights and privacy. So, did I miss anything on that version?
Thank you, gentlemen. I got 3 assembly members. We got 10 minutes left. John, you're first.
You hear and feel the helicopter goes over you as opposed to what's that like buzzing, but.
And there's only one.
Good.
Not necessarily, actually. If you used an aircraft and camera, you probably would never see it.
How about we get you dirigible that use electric motors, you won't hear it.
Going old school.
So a couple, just to embellish, so if you know, we're one of these two or something passed here in ordinance, so then your policies, what kind of things would your policies address here?
Our policies would probably, in addition to, so just generally speaking, police policies, in addition to addressing the legal operating parameters for whatever the activity is, they also tend to address more specific things about like, well, you need to use this particular equipment, but only if you've been trained in this way, and maybe you need to notify a supervisor, and the equipment needs to be stored at this location in this way to make sure that we don't break it. It's a lot more functional, kind of detailed type stuff.
Okay, so on this annual report, in the S version, it kind of pulls out that you have to send all that stuff for review, and it just says, throw your policy into a packet for an annual report. Is that pretty simple to do then? And then we can look at it and go, okay, we want Officer Smith to.
Yeah, and like I said, I mean, having the policy public is, I mean, the draft policy is already very public, and we would just continue with that. It'll probably be posted on the website with the other policies, so anybody can look at it anytime they want.
And then so on the deletion of the data, 24 hours, I guess is pretty quick. And then, so what, you have records retention policy, and you say you probably address this, what are some parameters on that?
Well, we have already some retention policies in place for some of the other video evidence we collect in digital photography. And then evidence collected in a criminal case, there's a whole assortment of rules that go along with how that's retained and disposed of. And so all this as evidence, it would fall under all those same rules. For non-evidentiary stuff, we have also some retention policy. And there are sometimes when you collect things that are maybe not immediately apparent as evidence, but then it becomes clear that it is evidence at some point. And so all of our retention policies are sort of designed with that in mind as well. And say, for example, you're using a drone, you capture some evidence or some footage, and then you illuminate it within 24 hours, and 2 or 3 days later, somebody comes forward with a complaint against the police department about, hey, we think you did this improperly, and now we've disposed of the footage of that incident, we wouldn't be able to adequately address that person's complaint. So I would be concerned about things like that. And these are some of the kind of unanticipated consequences of creating this excessively restrictive type of environment.
Quickly, because I've still got Chris and Mr. Falls.
Just quick, so if someone's house is burglarized and they have a camera, they send you that snippet of the guy smashing into their car, now you have that, do you retain that?
We do, yeah.
So that's
Retain it as
understandable.
evidence, yeah.
Okay.
Thank you, Chris.
Yeah, a couple things. On policy A4 on the original, this discussion briefly, Mr. Sherwood had talked about the drones not be used for manner violence versus reasonable expectation of privacy, basically under their Fourth Amendment rights. So I imagine a protest is happening. I'm imagining St. Louis, right, a place where we saw all kinds of major abuses, in my opinion, that happened. And what we heard was it would be protected unless there was a crime that was taking place, and then you could follow it into a crowd, right? Can you imagine a scenario where a really bad operator fomented trouble, right? Some kind of a outrageous event that then allowed the police to survey the whole event and turn it into a crime scene for themselves.
Yeah, I mean, that is possible, and I would also suggest to you that in that same circumstance, if you had footage of the police interaction with the crowd and there were complaints about what that was, that might be valuable as we're evaluating what the officers did on the ground, and maybe there was inappropriate conduct that we would want to be able to address. And so, I mean, I think that cuts both ways. I will tell you that, yeah, typically where you see a problem with the crowd is generally not the bulk of the crowd. You do have bad operators in there that start creating problems, and that can be something that if it becomes criminal activity that we could use a drone for. But again, I think that, ultimately having a video record of what occurred there is probably not a terrible thing for everybody involved.
One last question. In the discussion about review of policy, it seems to me there are two kinds of policies in play. One is kind of the how to keep the drones safe, how to keep people trained, all that stuff that most of us wouldn't care about because we know you guys are going to do a great job. But what they call in military rules, and I'm not military, so I don't know the details, it's rules of engagement. When it's proper and when it's legal to use these, it seems like those are the areas of policy that I'm most interested in having some kind of substantive engagement with before they become new policy, right? That's the area. And then the last thing, very briefly, would you please submit your comments in writing to us so we can have it in a way that we can work with it? Because this is kind of a lot to consume in a short amount of time.
Mr. Falsey.
I know we're short on time, so I'll just add a little bit. To review the briefing, it's for the 50,000 foot level. And remind you simply how we got here, which is that we had no prohibition on launching drones in the air a year ago. And that was sort of the original pitch. We asked the police department to work with the ACLU, other interested parties to develop a policy that would give us comfort that before we did that, we were on the right path. And then we showed that to you guys before we actually put any drones in the air. The good news is, I think that policy is largely where everybody substantively wants to land. And so now we're just trying to figure out how to give each other comfort that we have belt and suspenders and put all the right restrictions in place. The ordinance that Assemblyman Dunbar and now Assemblyman Wilson do, the substitute version I put on the table, is a new line of business for the Assembly. There's not really anything like this in the municipal code right now governing our use of police vehicles or guns or tasers or anything else. So there's a little bit of discomfort with that. But we have made ourselves comfortable, in part because we know that we're all really moving in the same direction here. I think as we walked in the room, we were prepared to say that we were willing to live with, of course, Assemblymember Dunbar's ordinance. I think that largely puts us in a place where we wanted to go. There is some wrinkle on subsection B about reporting internal policy, and that's not substantive rules of engagement stuff. That's rinky-dink things like the draft policy says the APD tactical support unit is in charge. Before you fly a drone, you got to ask the special operations commander. Before you fly a drone, you got to write down what the weather was like. We should be able to change all of that stuff just as a matter of executive prerogative, and I don't think you guys care whatsoever. So maybe some massaging on B. The last I'll say is the substitute version, I think, really is philosophically problematic. We've heard a lot of specific charges about things that would go awry if we worked off the substitute version. But I'll add just a few more. Subsection E says that NOA or an agent of the NOA can't operate a UAS that is not owned or operated by the MOA. That is not how we're doing business outside of the police department. SWS is flying UAA-owned drones to monitor how the landfill is being used now. They are keeping that data for much longer than 24 hours, even if it gets a little bit of including property or J-Bear property outside of the landfill line. So remember, this policy wouldn't apply just to the police department, but to all of our utilities across the board. I think there are other particular qualms you have about some of the language here. Subsection C says that you're supposed to operate the drone in the manner that the data collection on individual homes or areas other than the target is minimized. It's not clear what the target is in some of these instances. Maybe the target could be the landfill, maybe the target could be the right-of-way we're trying to survey for MLP, but then that's sort of everything. If there's a traffic accident, I'm not sure what's in and what's out, what's that count as the target. And to the extent that we have a search and rescue, if there really is a target, Bill is missing somewhere in the woods, I don't think it is really possible to manage the data in a way where you see only a pinhead of Bill when you find Bill and nothing else around it. So I think I understand the motivations for why it would be a sort of philosophical flip on that substitute version, but I think it takes us down so many rabbit holes that it's going to be hard to pull that out of the fire.
Thank you, Bill. And I will share your concern about separation of powers, because last time I pulled up the procedure manual, it's about 4 to 5 inches big. If you really go through every procedure manual, you'll have a good time trying to do it, because those don't come to it. Just like you see a lot of things that say, city employees must wear a badge. That's a procedure manual for the executive branch. It does not apply to assembly. We're a separate branch of government, so we don't get into theirs, nor do we really want to. Years ago when I was doing my master's, I rewrote the procedure manual. Spent 6 months doing that for my show. I do not intend to do that again. So if you want to get into it, have fun, because it's so detailed on what they do. And if you want to do that, I suggest you run for mayor. Because there's a separate branch of government. We define what the Assembly does, legislative branch would do what the executive branch does. We don't muck in theirs and they don't get into what we do. Mr. Dunbar.
Thank you. Well, I think there's a member of the public here. I'd like to have time to speak if you'd like. Not, no worries. I guess I would disagree with you a little bit on that procedure point you just made, because these aren't purely internal procedures. These are procedures relating to a device we use to observe the public in one way or another, public or a crash site or whatever. It's a little bit different than internal employee policies. And in fact, Bill kind of portrayed it like, we wouldn't have even thought about this had they not come to us. But I think you were required, to use these, you had to create a policy under that Alaska statute, right?
We did create a policy.
Right. You didn't have to come and show us. I mean, that was your mistake. But you had to create it. You couldn't have just put drones up in the air under state law. You had to create this policy. And the policy specifically had provisions here, provisions in it, like the provisions I have here, that related to the way they used it in relation to the public, not just purely internal. So I think it is a little bit different than purely internal procedures. But I am open to continuing this conversation with regards to subsection B. So I just want to say sort of procedurally, I introduced this, it's up on the 13th. My intent would be to move my version, have public comment on it, hear from members of the public. And then I probably will, I almost certainly will, make a motion to delay it to the following meeting so we have time to continue to work on this kind of stuff. And so I guess what I'd ask from you, John, and perhaps you want to move your S version, but what I would kind of like to see is, I think there are parts of the S version that I'm interested in, maybe even the administration's interested in, and if they were introduced as amendments rather than a wholesale revision, I think it'd be a little bit easier to get our hands around it, our arms around it, rather. So that's what I intend to do. Obviously, I am just one person, so if you guys decide you want to move the S version and have 6 votes for it, then so be it.
Mr. Halls, have you talked to the mayor about this yet?
Yes, we talked to the mayor about
I talked to him about the S version because I worked with 6 mayors, and believe me, some of them have not wanted you to miss the policy procedure manual. And it may take 6 votes to pass, but the mayor vetoes it takes 8. So just find out where he's coming from on this before you get too big on the pike, please.
Just based on that, the S version does not have the assembly messing with the policy and procedure manual. It just says on the annual report that it's not really it. So I think
That might be
the
some-
regular version says you do, but I think it's fine. I think I'll look at it again, and I think there are some things that should be presented as amendments to your. But one thing, we have newly enlivened the Public Safety Advisory Committee, and I would be, if you send a vote to them and say, see what they say. Not even making a choice, just see what they say.
Do we have a
Or
personal privacy
Eric's
advice?
group.
Do we also hear from
Should create.
This?
Yeah.
Well, we're doing it now, but I'd be glad to do whatever you need.
And for me, it's just that issue of the rules of engagement. I would love to have some kind of a procedural review of that part. Everything else I could question, and I'd love your input on how to achieve that.
The citizen, did you want to make a comment? Dean?
Just a procedural point, we don't have an S version on the agenda yet, so if one is moved, it needs to be laid on the table on Tuesday.
Can you send the layout to John?
Or get it to Heidi? Okay. Get it to Heidi so she can get it scheduled. Thank you. This work is over. Thanks for being here.